This is Florida Attorney Randall Love, and if you're a Florida employer, we need to talk about our veterans. Federal law provides employment protection to veterans returning to civilian jobs after military service. The purpose of the law is to encourage service in the uniformed services by eliminating or minimizing the disadvantages to civilian careers and employment which can result from such service. The law also seeks to minimize the disruption to the lives of persons performing services in the uniformed services, as well as to their employers, their fellow employees, and their communities by providing for the prompt reemployment of such persons upon their completion of such military service. The law has two prongs. First, the law prohibits discrimination against people who served in the uniformed services. The law provides that a person who is a member of the armed services shall not be denied initial employment, reemployment, retention in employment, promotion, or any benefit of employment by an employer on the basis of that membership, application for membership, performance of service, application for service, or obligation in the uniformed services. The law further provides that an employer may not discriminate in employment against or take any adverse employment action in retaliation against a person who has sought to enforce their rights under the law. Simply stated, an employee may sue an employer who discriminates against the employee because the employee is a member of the uniformed services. An employer shall be considered to have engaged in unlawful activity if the person's military service or application for service is a motivating factor in the employer's action, unless the employer can prove that the action would have been taken in the absence of such military service. Thus, the law does not prevent an employer from firing an incompetent employee even though the employee is in the military service or the reserves. The second prong of the law provides veterans with rights to reemployment at their prior jobs upon returning from service. A person returning to civilian life is entitled to reemployment if he or she has given advance written or verbal notice of such service to such person's employer. The cumulative length of the absence and of all previous absences from a position of employment with that employer by reason of such service in the uniformed services does not exceed 5 years, and the person reports to his or her employer or submits an application for reemployment to his or her employer. The employer, however, is not obligated to rehire the returning veteran if the employer can prove that such employment would impose an undue hardship on the employer.